This training is to fulfill the requirements of Section 601 of Title VI of the Civil Rights Act of 1964, the Civil Rights Restoration Act of 1987, Tennessee Attorney General's Opinion Number 92.47, Tennessee Code Annotated 4-21-904, and DCS Policy 24.10. This training will be an overview of the principles of Title VI of the Civil Rights Act of 1964 and is intended to be an abstract of the issues that concern Department of Children's Services enforcement and compliance. It is not intended to provide a complete and comprehensive review of all issues related to Title VI. Our focus is to help develop and increase awareness, sensitivity, and objectivity in carrying out the Department of Children's Services compliance efforts. Our goal is to ensure that the civil rights of beneficiaries of DCS services and programs are protected and that all beneficiaries have equal access to programs, activities, and services regardless of race, color, or national origin. This course will include the definition of Title VI as set forth in the state's policy statement on Title VI requirements. Tennessee Department of Children's Services Policy 24.10 states, "No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or otherwise subjected to discrimination under any program or activity operated, funded, or overseen by the Tennessee Department of Children's Services." It is the intent of the Department of Children's Services to bind all agencies, organizations, or governmental entities operating under its jurisdiction and control to fully comply with and abide by the spirit and intent of Title VI of the Civil Rights Act of 1964. DCS will ensure culturally competent services and programs to effectively meet the needs of the children and families served. DCS shall ensure that a process is in place for the provision of services and benefits to eligible individuals who, as a result of national origin, are limited in their English proficiency. We will also cover how to apply the state's policy statement to your workplace, the description of your responsibilities and liabilities under the state's policy statement and state and federal law, how you can develop strategies for recognizing and preventing disparate treatment, and how to report a Title VI violation. Title VI prohibits discrimination on the basis of race, color, or national origin in programs and activities receiving federal financial assistance. Specifically, Title VI provides that no person in the United States shall, on the basis of race, color, or national origin, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. We will now review the regulations relevant to implementing Title VI. The Code of Federal Regulations reads in part, "A recipient under any program to which this part applies may not directly or through contractual or other arrangements, on grounds of race, color, or national origin, deny an individual any service, financial aid, or other benefit provided under the program, or provide any service, financial aid, or other benefit to an individual which is different or is provided in a different manner from that provided to others under the program." A recipient, in determining the types of services, financial aid, or other benefits or facilities which will be provided under any program, or the class of individuals to whom or the situations in which services, financial aid, or other benefits or facilities will be provided, may not directly or through contractual or other arrangements utilize criteria or methods of administration which have the effect of subjecting individuals to discrimination because of race, color, or national origin, or have the effect of defeating or substantially impairing accomplishment of the objectives of the program with respect to individuals of a particular race, color, or national origin. Federal regulations are reinforced by Tennessee state law. The Tennessee Code Annotated says, "It is a discriminatory practice for any state agency receiving federal funds, making it subject to Title VI of the Civil Rights Act of 1964, or any person receiving funds from a state agency, to exclude a person from participation in, deny benefits to a person, or to subject a person to discrimination under any program or activity receiving such funds on the basis of race, color, or national origin." What is Title VI? Title VI of the Civil Rights Act of 1964 is a federal law prohibiting discrimination based on race, color, or national origin. It covers all forms of federal aid except contracts of insurance and guarantee. It does not cover employment, except where employment practices result in discrimination against program beneficiaries or where the purpose of the federal assistance is to provide employment. Simply stated, Title VI mandates that all persons must be treated equally without regard to their race, color, or national origin. People may not be excluded from participating in, denied the benefits of, or discriminated against in the programs, services, or activities of an entity receiving federal funds. What is the purpose of Title VI? The purpose of Title VI of the Civil Rights Act of 1964 is to prohibit programs that receive federal funds from discriminating against participants on the basis of race, color, or national origin. What is discrimination? Discrimination is making any distinction between one person or group of persons and others, either intentionally, by neglect, or by the effect of actions or lack of actions based on membership in a protected class. What are civil rights? Civil rights are enforceable rights or privileges guaranteed by the 13th and 14th Amendments to the U.S. Constitution, which, if interfered with by another, gives rise to an action for injury. Here are some examples of civil rights: freedom of speech, freedom of assembly, the right to vote, equality in public places, and freedom from involuntary servitude. What is the historical basis for the Civil Rights Act of 1964? Title VI was not the first attempt to ensure non-discrimination in federally assisted programs. For example, various prior executive orders prohibited racial discrimination in the U.S. Armed Forces, employment by federally funded construction contractors, and federally assisted housing. Various federal court decisions also serve to eliminate discrimination in individual federally assisted programs. Congress recognized the need for a statutory non-discrimination provision such as Title VI to apply across the board to make sure that the funds of the United States are not used to support racial discrimination. 110. As stated by Senator Hubert Humphrey in the Congressional Record, the Civil Rights Act of 1964 was a product of the growing demand from civil rights leaders for the federal government to launch a nationwide offensive against racial discrimination. In calling for its enactment, President John F. Kennedy identified simple justice as the justification for passage of the Civil Rights Act of 1964. In 1963, President Kennedy defined simple justice as follows: simple justice requires that public funds, to which all taxpayers of all races contribute, not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination. Title VI mandates that all persons must be treated equally without regard to their race, color, or national origin. The Supreme Court has addressed the term person in the context of challenges brought under the Fifth and 14th Amendments, and has held that undocumented aliens are considered persons under the Equal Protection and Due Process Clauses of the Fifth and 14th Amendments. Thus, one may assume that Title VI protections are not limited to citizens. Title VI protects individuals and groups of individuals from discrimination. You are a member of a protected class if you belong to any group of individuals with the same characteristics that are protected from disparate treatment by federal law and statutes. Race is a protected class. Race distinguishes one population of humans from another. The most widely used human racial categories are based on visible traits and self-identification. An example of racial discrimination would be to deny program services, aids, or benefits, or to make assignments based upon visible traits. Color is another protected class. Color denotes a group of people recognized as a class on the basis of the visible characteristic of skin pigmentation. We would be discriminating on the basis of color if we provided a different service, aid, or benefit, or provided services, aids, or benefits in a manner different than they are provided to others based upon skin pigmentation or the lack thereof. National origin is a concept that may refer to an individual's place of birth. National origin is another protected class. Discrimination on the basis of national origin would include segregating or separately treating individuals in any manner related to the receipt of any service, aid, or benefit. An example of this would be erecting a language barrier to services based upon an individual's place of birth. Individuals with limited English proficiency may encounter language barriers to fully accessing benefits or services. Limited English proficiency, or LEP, is defined as individuals who do not speak English as their primary language and who have limited ability to read, speak, write, or understand English. These individuals may require language assistance with respect to a particular type of service, benefit, or encounter. The LEP requirements are as follows. A recipient or provider whose policies or practices exclude, limit, or have the effect of excluding or limiting the participation of any LEP person in a federally assisted program on the basis of national origin may be engaged in discrimination in violation of Title VI. In order to ensure compliance with Title VI, the recipient or provider must take steps to ensure that LEP persons who are eligible for their programs or services have meaningful access to the benefits that they provide. The steps taken by a recipient or provider must ensure that the LEP person is given adequate information, is able to understand the services and benefits available, and is able to receive those for which he or she is eligible. The recipient or provider must provide the language assistance necessary to ensure such access at no cost to the LEP person. Next, we will discuss how to apply the state's policy statement to your workplace. You must ensure that the civil rights of beneficiaries of DCS services and programs are protected and that all beneficiaries have equal access to programs, activities, and services regardless of race, color, or national origin. More specifically, you must ensure that DCS employees have received appropriate and adequate annual training on Title VI to function fully in their responsibilities associated with Title VI compliance and implementation, and that DCS employees have received all available materials, such as posters required for administering and complying with the Title VI program. The departmental Title VI officer will maintain copies of compliance reports from regional offices, youth development centers, DCS community programs, and contract agencies for 2 years. The director of CIS grant programs will maintain compliance reports from CIS grants programs. Title VI posters informing clients of their rights to program access under Title VI provisions will be placed in waiting rooms, reception areas, and other initial points of entry. These posters will be maintained in any regularly encountered languages established by the LEP survey or assessment, as well as in English. In order for Title VI to apply to a particular program or agency, 1. The program or agency must be located within the United States. 2. The program or agency must be providing a service. 3. The program or agency must be receiving direct recipient or indirect subrecipient federal funding or assistance. A wide variety of programs, services, and benefits are covered by Title VI. Educational benefits, social services, tax benefits, health care, housing, and a host of other benefits and services all are covered under the umbrella of Title VI. Please note that the list of benefits, programs, and services provided here is not all-inclusive. We mentioned that programs or agencies must be receiving direct or indirect federal funding or assistance to be covered by Title VI. What qualifies as federal financial assistance? It's more than just money. Federal financial assistance includes aid that enhances the ability to improve or expand allocation of a recipient's own resources. For example, student aid, training of employees, grants and loans, and tax-exempt bonds all qualify as federal financial assistance. Property, tax incentives and tax-exempt status, and technical assistance may also be included in the federal financial assistance category. How does Title VI apply to public policy? By legislative mandate, Title VI examines the following public policy issues: infrastructure development, provision of services, accountability in public funds expenditures, economic empowerment, program service delivery, public-private partnerships financed in part or in whole with public funds. Disparate impact. Minority participation in decision-making. Site and local facilities. Accessibility for all persons. And comprehensive method of administration to ensure enforcement and compliance at the state or local level. Who must comply with Title VI? All of the following entities must be in compliance. State and local government. This category includes agencies distributing federal assistance or entities distributing federal assistance to state or local government entities. Higher education, including colleges, universities, and other post-secondary institutions. Entire corporations, partnerships, and private organizations. Private organizations in education, housing, and healthcare. And entire plants, private corporations, or other organizations which are geographically separate facilities to which federal financial assistance is extended. Let's summarize what Title VI does. Title VI prohibits entities from denying an individual any service, financial aid, or other benefit. Prohibits entities from providing services or benefits to some individuals that are different or inferior to those provided to others. Requires assurance of non-discrimination in purchasing of services. Prohibits locating facilities in any way that would limit or impede access to a federally funded service or benefit. Requires entities to notify the eligible population about applicable programs. Prohibits discriminatory activity in a facility built in whole or in part by federal funds. Prohibits segregation or separate treatment in any manner related to receiving program services or benefits. Prohibits entities from requiring different standards or conditions as prerequisites for serving individuals. Encourages the participation of minorities as members of planning or advisory bodies for programs receiving federal funds, and requires information and services to be provided in languages other than English when significant numbers of beneficiaries are of limited English-speaking ability. As you can see, the scope of Title VI is very broad. However, there are some limits to what Title VI covers. Title VI does not apply to federal assistance provided through insurance or guarantee contracts. For example, Title VI does not apply to FHA loan insurance. Title VI does not provide relief for discrimination based on age, sex, geographical locale, or wealth. The legislation only applies to contracts and set-aside programs. Title VI does not apply to employment, except where employment practices result in discrimination against program beneficiaries or where the purpose of the federal assistance is to provide employment. And Title VI does not apply to direct benefit programs such as Social Security. By now, you may be confused about what Title VI does and does not do. Here is the key to understanding Title VI compliance. To be in compliance, an agency must ensure that service beneficiaries receive equal treatment, equal access, equal rights, and equal opportunities without regard to their race, color, or national origin, including limited English proficiency. How is a Title VI complaint filed? A Title VI complaint may be filed by an individual, a class, or by a third party within 180 days from the date of the alleged discriminatory act. A complaint must include the following: your name, address, and telephone number. A complaint must also include the name and address of the institution or agency you believe discriminated against you. Complaints should also include any other relevant information.
Send your complaint to your local Title VI representative or DCS Office of Civil Rights, 315 Dedrick Street, UBS Building, 12th floor, Nashville, Tennessee, 37243. The office number is 615-532-5552 and the fax is 615-532-7602, or Tennessee Human Rights Commission, 312 Rosa L. Parks Avenue, 23rd floor, Nashville, Tennessee, 37243.
We will end this training by providing a list of definitions of terms that were used throughout the training. Review of these definitions should enhance your understanding of the content addressed in this training. Beneficiaries. those persons to whom assistance, services, or benefits are ultimately provided. Complainant. Any person who believes themselves or any specific class of individuals to be subjected to discrimination prohibited by Title VI and makes or initiates legal action or a proceeding. Complaint. A verbal or written allegation of discrimination which indicates that any federally assisted program is operated in such a manner that it results in disparity of treatment to persons or groups of persons because of race, color, or national origin. Compliance. The fulfillment of the requirements of Title VI under any applicable laws, implementing regulations and instructions to the extent that no distinctions are made in the delivery of any service or benefit on the basis of race, color, or national origin. Compliance review. Regular, systematic inspections of agency or provider programs to determine regulatory compliance with civil rights laws and regulations. Compliance reviews determine compliance and non-compliance in the delivery of benefits and services in federally assisted programs. Contractor. A person or entity that agrees to perform services at a specified price. Discrimination. To make any distinction between one person or group of persons and others, either intentionally by neglect or by the effect of actions or lack of actions based on race, color, or national origin. Federal assistance. Any funding, property, or aid provided for the purpose of assisting a beneficiary. Minority. A person or groups of persons differing from others in some characteristics and often subjected to differential treatment on the basis of race, color, or national origin. Non-compliance. Failure or refusal to comply with Title VI of the Civil Rights Act of 1964 or other applicable laws, and or failure to implement departmental regulations. Parity. The proportion of minority participation to the minority eligible population of a service delivery point is the same as the proportion of non-minority participation to the non-minority eligible population of the same service point. Program. Any program, project, or activity for the provision of services, financial aid, or other benefits to individuals, or the provision of facilities for furnishing services, financial aid, or other benefits to individuals. Public notification. The process of publicizing information on the availability of programs, services, and benefits to minorities and statements of non-discrimination. This is attained through use of newspapers, newsletters, periodicals, radio and television, community organizations, and grassroots and special needs directories, brochures, and pamphlets. Recipient. Any state, political subdivision of any state, or instrumentality of any state or political subdivision, any public or private agency, institution, or organization, or other entity or individual in any state to whom federal financial assistance is extended, directly or through another recipient, for any program, including any successor, assignee, or transferee thereof, but not including any ultimate beneficiary under such program. Vendor or provider. An individual, group, public or private organization or institution, political entity, or commercial enterprise which, pursuant to any contract, agreement, or other arrangement with a recipient or subrecipient, provides generally required goods or services which are used by or available to a beneficiary of a program.